गुड इवनिंग एवरीवन। आई होप आप लोग सब घर पर हैं और जो लोग घर से बाहर निकलने की कोशिश कर रहे थे आई होप वो लोग बैठ उठ पा रहे हैं आराम से, उन्हें कोई तकलीफ नहीं हो रही है। तो टुडे विल बी डूइंग सेक्शन 124 ऑफ आईपीसी एंड द एलोकेशन ऑफ पार्टी सिंबल्स। सेक्शन 124A of IPC deals with the sedition law. So firstly, look at the expected questions from this topic. The first question is, who among the following were tried under the sedition law? महात्मा गांधी, लोकमान्य तिलक, जोगेंद्र चंद्र बोस. Choose the correct answer. Appearing in court who referred to section 124A as the prince among the political sections of the Indian Penal Code designed to suppress the liberty of the citizen. The options are Mahatma Gandhi, Lokmanya Tilak, Lord Curzon and Motilal Nehru. Those who know the answer, give the correct answers in the comment box below, and rest they just go through the video and they'll be in a position to answer these questions comfortably. Now, let us begin with the sedition law. Sedition is given under the section 124A of the IPC 1860. There can also be a question that 124A is part of IPC, CRPC or Code of Civil Procedure. So the answer is IPC 1860. Sedition in this section is defined as whoever by words either spoken or written or by signs or by visible representation or otherwise brings or attempt to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may extend to 3 years. Now understand that it is related to all the forms of expression, that is by word, spoken or written, or any forms of sign. Also, it uses the word disaffection, where the disaffection means disloyalty or feeling of enmity. The word is government, however, it includes the state and the national orders also. Another explanation is means expressing disappropriation of the administrative or other action of the government without exciting or attempting to excite hatred, contempt or disaffection do not constitute an offense under this section. It means in order to be tried under sedition, there has to be incitement of an offense or there has to be the excitement of hatred. Now, if you go into the history of the sedition law, the question that can be expected is who was the first person to be tried under the sedition law? That is the section 124A of the IPC 1860. We generally read this question and we consider that the answer is Lokmanya Tilak or Bal Gangadhar Tilak. However, the first person to be tried under the section 124A was Jogendra Chandra Bose. Second person or important from among the famous freedom fighters, Lokmanya Tilak was also tried under this law, and also our father of nation, that is Mahatma Gandhi, was also tried. He called this law as the prince among the political sections of the Indian Penal Code designed to suppress the liberty of the citizen. This law has been in news where so many activists and political leaders were booked under the section 124A or FIRs were registered under this section. So we may expect a question in prelims. We are not going into the critical analysis of this question because that is not under the ambit of prelims and we will be later on discussing that in mains. Important point in this is whether the courts considered this law as legitimate or not. So in that we need to go through the two important cases of Supreme Court. First was in the year 1962, which was Kedarnath Singh versus the state of Bihar, where Supreme Court has established that the section 124A is constitutional, but the application has to be limited. This limited application should be only in the cases where the intention or tendency is to create disorder or disturbance of law and order or incitement of violence. Also in the same case, Supreme Court distinguished from very strong speech or the use of vigorous words strongly critical of the government. The same view was upheld by the Supreme Court in the Balwant Singh versus State of Punjab case, where the Supreme Court established that mere sloganeering will not amount to sedition given that it is not leading to any violence or incitement of any offense. The another topic that we'll be discussing today is the allocation of party symbols. The expected question from this topic may be, first, consider the following statements regarding the allocation of party symbols. First statement, the Section 29A of Representation of People's Act 1950 governs the election symbol reservation, allocation, order and registration of political parties in India. Second statement, the Election Symbols Reservation Allotment Order 1968 empowers the Election Commission to recognize political parties and allot party symbols. Third statement, the recognized parties cannot have same symbol even if they are not contesting in the same states. Now, it was in news where the political parties, they went to the Election Commission regarding the allocation of symbols, whether it is the factions of Samajwadi Party or whether it is the factions of AIDMK. They were contesting to have a political symbol. That is why this question is important. Now, Section 29A of Representation of People's Act 1951. I'm repeating again, Section 29A of Representation of People's Act 1951. It is not 1950, it is 1951, and this is very important because it is specifically mentioned in our syllabus. So it is 1951 which governs for the allocation of symbols and the registration of political parties. The power to allot the election symbols and to recognize that dispute is given to the Election Commission through Election Symbols Reservation and Allotment Order 1968, which aims to provide for the allocation of symbol and the recognition of political parties.